Good morning, good afternoon, good evening, everyone, depending on where you are. I am in New Haven, Connecticut. I am from Italy. I teach philosophy and political theory at Quinnipiac University. And I have the privilege this morning here to moderate, not chair, but moderate. And I will make an effort to stay back and convey the questions and the comments of the audience to our distinguished speakers. And before we start, my proposal is that of having the speakers presenting separately and having Q&A after each presentation. Because not all of our speakers can remain until the end of this 3-hour-long panel. This panel is about COVID-19 and its unequal impacts. Our first very distinguished speaker is a privilege and an honor for me to introduce Professor Pistor to the audience. Katharina Pistor will present a lecture on law as unequalizer, on the distributional effects of law in times of crisis. Professor Pistor is Edwin B. Parker Professor of Comparative Law at Columbia Law School and Director of the Law School Center on Global Legal Transformation. Her research and teaching spans corporate law, corporate governance, money and finance, property rights, comparative law, and law and development. She has published widely in legal and interdisciplinary journals and is the author and co-author of more than, I would say 20, maybe 19 books. She's the recipient of the Max Planck Research Award 2012 and several grants, among others, the Institute for New Economic Thinking and the National Science Foundation. The most recent book is titled The Code of Capital: How the Law Creates Wealth and Inequality. This is published by Princeton University Press in 2019. I would let Professor Pistor give her lecture, and which is again titled Law as Unequalizer, on the distributional effects of law in times of crisis, in the hope to have a Q&A moment starting perhaps a few minutes before 10. But well, let's see how it.
Thank you very much for this very kind introduction. I will share my screen here so that you can see my PowerPoints. So I just wanted to put this a little bit in perspective. I will talk about COVID, but I think I first want to lay the foundations as to why I'm saying that law is an unequalizer. I'm basically saying even in normal times, law operates as unequalizer, even when we assume formal equality before the law and unrealistically a fairly even distribution of wealth. When we do neither, of course, the effect of law as an unequalizer become aggravated. The reason is that law ranks rights, enforces stronger versus weaker rights. And the relative strength of these rights is non-random. That's critical. So we have to think about how stronger rights are created and why some folks have stronger and others have weaker rights and who sets these rights. So I think there's nothing fundamentally wrong about having stronger rights or weaker rights, but the key question is who is behind that and how is the allocation of rights legitimated in society. In times of crisis, individuals or entities survive better, have a greater chance of surviving if they have stronger rights and can enforce them, if they have access to support, such as in financial systems, unlimited liquidity, support from central banks, from the most powerful central banks in the world, or if they are the beneficiaries of state intervention. And now comes the irony here, if states intervene and sometimes suspend or relax the full force of the law that otherwise makes debtors so dependent on their creditors and can drive debtors into despair, because sometimes the policymakers, legislatures, or even courts intervene and declare debt moratoria or creditor bailouts, or facilitate liquidity provisioning, even where there's no legal reason or has been no legal reason ex ante. So in times of crisis, we always see a lot of discretion come in, but the question is, again, for whose benefit is the discretionary power of the state then exercised to relax the binding forces of the law that in times of crisis can bring the entire system to its knees? I will say more about this later. So we typically assume formal equality before the law. We do this in particular in constitutional law. I'm more interested in private law. And so I'm basically saying not all rights are equal. Some have priority rights, stronger rights than others. That's what law does. So, I would say more about the details in a second. In my book that has been mentioned, The Code of Capital, I basically say that capital assets have a handful of attributes. The three most important perhaps are priority, that is that you have stronger rights vis-a-vis others, durability, that you can insulate your assets against too many different claimants, too many different creditors. Convertibility is a kind of an insurance device that allows you to flip your assets into a safer asset, typically the legally issued tender of a powerful state, that is dollars or yen or pounds, maybe euros, but not necessarily, let's say, pesos of Venezuela or other countries that have problems supporting their currencies. So, and if these rights are enforced against the world and are made universal, then you have a powerful right to defend elsewhere, to defend them. And last but not least, of course, if you are building your wealth and your power around legal institutions, you want to have access to courts if necessary. So the rules that determine who has standing to bring a case in court and the resources to pay your lawyers up front or pay even the legal cost matter, unless you have contingency fees or other conditions. But let's just leave this aside for now. So when we rank rights in private law, if you just look around, you can immediately see this. We have property rights that are stronger than contractual rights. We have secured creditors that have stronger rights than unsecured creditors. We have creditors versus debtors, and we have come to a point where creditors have fortified their rights much more so than debtors have rights to defend themselves. This has not always been the case. It's very much a question of political economy, how the relative allocation of rights and responsibility pans out. We have controlling shareholders versus minority owners in business organizations. We have shareholders versus other stakeholders, that is, employees or creditors or the community, the environment in corporate law, and we have priority rules in bankruptcy. So wherever you look, once you look for the ranking of rights in private law, you can find it. And I think it's always important to ask, who made that decision? How did we get here? And what implications does it have for those on the other side? So it's basically like having a deck of cards and pulling out the ace or pulling out the joker and being able to win the legal game in that fashion. That is really important. There's also a possibility to recreate many of the rankings that you can find in law through contractual arrangements and information technology that allows us to contract with millions of people at the same time on the same terms has made it all the much easier for those who control the contract at the outset to impose their own preferred rank orders and contractual obligations on the rest of the world. So you're all familiar, I'm sure, with Anatole France's famous dictum that folks, are equally empowered to sleep under the bridges. Sorry, this is so both the rich and the poor can sleep under the bridges. But this is, if we add that, then what I'm saying becomes all the more important. But I also want to make the point that even if we control for the vastly unequal allocation of resources, the law actually structurally reinforcing inequality. And I think the two, of course, go together. If you have stronger rights, you're more likely to accumulate wealth over time and protect it. In the future, if you're poorer, you are much more exposed to the vulnerabilities of economic cycles, and you won't be able to defend your rights unless you get explicit help from these institutions later on. Okay. So for whose benefit are we ordering? There is sort of an assumption very often in the social sciences and political discourse on a daily basis that private legal ordering in markets and in the economy takes place within parameters that are set by state law, that we have an enumerated set of property rights, and that we have clear conditions for what we recognize as an enforceable contract. And that's what we also teach our law school students in their first year, that property rights are enumerated, and then contracts have to meet certain conditions to be enforceable in law. But in fact, these parameters are much more flexible and malleable in the hands of sophisticated lawyers. And we have pushed the system pretty hard to be able to recreate at least the semblance of property rights through private contractual mechanisms, and to get courts to recognize other legal institutions or other claims as property-like, so that we have actually outsourced to private parties the ability to create their own superior rights and enforce them against others. And there are fundamental reasons for that, even outside the political economy. One is that law is, of course, inherently incomplete. It is malleable, also meant to be malleable, so that you can organize your private affairs. So not everything is, from the outset problematic, but these are the entry doors, if you wish, that you can use sort of to capture the law and make it malleable for your own purposes. And the techniques are well known to any lawyer. We make analogy arguments, we fill gaps in the law with, of course, certain types of interest. We combine different legal modules to create something completely new. And of course, there's a lot of power of legal reasoning. And of course, where the end of legal reasoning is something that is subject to debate. Last but not least, we have made it increasingly easy for sophisticated parties to choose the law by which they wish to be governed. These are the choice of law rules or conflict of law rules. So I can use the laws of the neighboring states in the United States, where I never want to do business, but I like the laws better because they support my interest. I can do this even globally because most states now recognize and enforce the laws of other countries, even if the business who choose them have never set foot there. And of course, last but not least, and I said this before, access to legal services is important in a world that is so deeply coded in legal rights and privileges. Okay, let me just... So how do we protect one's rights in private law? How do we defend ourselves against that? One important thing to realize in private law is that we don't have a state that polices private law. And it's basically up to other private parties to police private law. And so we have a powerful first mover advantage built in the creation of private legal rights and privileges. I can basically try to do a private transaction. I create a new type of legal institutional arrangement for my client as a lawyer and let him run with it. I, of course, check case law, I check statutory law, I check regulation to make sure that what I create fits through the gaps of the scaffolding that is the legal system as we know it, so that I can give a comparative advantage to my client, hoping that he does not infringe the law. If this is struck down a couple of years later, that's too bad. But then at least the client has made some money in between. And of course, as a lawyer, I'm trying to protect him from being struck down. And that's, of course, the sophistication that goes into transactional lawyering these days. So the real issue is that on the other side, if you're arguing that your rights have been infringed by somebody else, that the contract should not be enforceable against you, you're always playing defense. And you carry the burden of playing defense. You have to bring a case to court, you have the burden of proof. You have to find the evidence that suggests that there has been wrongdoing. And of course, you face the cost of litigation. Same basically for regulators. We have, of course, established in many countries regulators that police a little bit on the fringes, I would say, behavior, whether it's antitrust, financial regulation, and other things. But most of the action, I would argue, is really happening in the space of private law, where private actors would have to raise a flag first before maybe down the road, after a major crisis, we establish regulation that tries to rectify some of these issues. So one thing that has happened over time, and increasingly so during the last several decades, is that we have tightened the legal commitments we make in private law, in part because there was a great desire to scale legal relations, economic relations beyond, of course, localities, beyond the nation state to the global level. And that basically means we have to make rigid contractual commitment that become tradable assets in their own right. So you can think of legal relations on a continuum from relational contracts. Of course, there could be relations that don't even have a legal aspect, but we can still have relational contracts where two parties know that they are sort of dependent on each other, and therefore also might renegotiate their contractual relationship in the future if something substantially different happens in their environment. Then we can move to a stage where we want to really make credible commitment and minimize the prospect of anybody renegotiating a contract. So we make them binding, but we allow some exceptions. We could say something is a force majeure event, something is an exceptional event no party had anticipated, and we adjust or renegotiate the contract later. What is a force majeure event, of course, is a big question. It has been battled out also in the COVID crisis. Some force majeure clauses in major merger agreements did not even recognize a pandemic as a force majeure event. So you can't get out of a contract under those conditions either. And then last but not least, if you really want to have a financial asset that you can sell easily in major financial markets, you want to have a binding commitment that doesn't allow for renegotiation. So just to illustrate this in another way, if you think of a creditor and borrower, and you think of a bank that gives loans to different types of borrowers, the bank to some extent becomes increasingly dependent on these borrowers actually to pay back. But this also means that it might be willing to renegotiate a loan to make sure that it will get the money back eventually, even if not under the terms of the original contract, then eventually. The downside of this arrangement, of course, is that the risk is concentrated in the bank, which is why we regulate banks, which is why we're saying banks have to keep equity and have to make sure that they can absorb some of the losses before they fail themselves. But what actors in the private financial world have tried to do is basically to recreate banking relationship through private law mechanisms outside banks. And the way to do this was to make really the contractual relations that we make ever more binding, ever more rigid. So the marketization of financial relation has gone hand in hand with the rigidity of the contracts that we use to create them, because otherwise we can't trade these assets in global financial markets, as I said before. So we have basically unpacked a bank into a chain of contractual relations. Here's the debtor. This could be a homeowner. It could be somebody who leases a car. It can be a little firm that needs sort of bridge finance, and rather than going to a bank, might be able to access financial markets in a different way. You have a loan originator that might originate multiple loans to multiple debtors, sell them to a buyer. The buyer then sets up a trust. So you have a trust sponsor that sets up a trust, which is a legal creature that protects these assets behind the trust, inside the trust, from too many different creditors. That's the durability function I mentioned earlier. The trust then sells interest in the trust to investors. The investors very often have their own creditors, and the creditors, of course, have their own owners. Now, this is highly, highly simplified. At every stage here with the investors, you, of course, also have owners in addition to creditors. So I could elaborate this more, but I just wanted to show that from the bank, which is sort of the bubble in the middle, you get a chain of contractual relations, and how these contractual relations are built is important to look at. Now, we can take out some of these elements here, and in fact, the law is used to basically marginalize the loan originator, the wholesale buyer, and the trust sponsor, so that the investors who buy assets in the trust don't have to think about whether these guys are viable. All we want to think about is that there are enough debtors that make regular payments on their loans that go into the trust, and then the investors get what they want to get. And what the investors want to get are fixed payments. They don't want to pay, basically carry the risk of payments that change on a daily, weekly, monthly basis. They want fixed returns. And of course, once you have fixed returns, you can see how this tightens the system, because if the debtors don't always pay, then the ability to pay these fixed returns, of course, becomes a problem. The investors then also have fixed returns to be paid to their creditors, and the creditors might have owners who have redemption rights. And if they have redemption rights, they could at any moment ask to get their money back, exactly the amounts that they have paid in. And you can see how this can then destabilize the entire system. So we have created a system increasingly, and not only in the United States, you can see this globally. You can see this also for sovereign debt relations, for project finance, syndication of loans. Many of them use securitization and similar structures to lower the cost of credit on the left-hand side. But this comes, and this is the flip side of the coin, this comes at the cost of contractual rigidity and a strong creditor bias, because this works only from the point of view of the creditors, that they're saying, we always say they diversify their risk, but it basically means that they tighten the screws on the debtors. Now, I've written about this earlier in a paper called The Legal Theory of Finance, where I've basically said we need these tight legal commitments to build financial systems, but under conditions of fundamental uncertainty that we can't escape, and liquidity volatility. The two are related. The system can self-destroy. When the system sort of approaches the abyss and might self-destroy, it can be rescued by relaxing the full force of the underlying legal commitment, which can take different forms. It could be a bailout, a moratorium. It could also be offering liquidity to some, but not all, when no liquidity is owed. Yeah, somebody who has never paid for the regulation or for insurance, but then gets the insurance from the state. And of course, that's what happened when we did our quantitative easing programs and other bailout mechanisms. So when you look at what happens, it's not necessarily what has to happen, but I think it's built into our system. When you look at what happens in rescue efforts, it's typically that the central banks of powerful countries tend to rescue the entities and actors that are critical for the survival of the system, but not the rest. So there's a hierarchy of relations built into the financial system. Financial systems are hierarchical. Harry Merling has written a lot about this. And you can see this literally when you look in financial crisis, who gets the benefit of central bank intervention. These are entities that have already institutional access to central banks, like regulated banks. That's fine. It becomes more problematic when other entities that have not been regulated, but that are now deemed too big or too interdependent to fail, also benefit from that or beyond that. So you can look at this in the 2008 crisis. You can also look at this in the COVID crisis. I will come back to that, is how quick central banks, especially the Fed, can intervene and make liquidity available to asset holders, including holders of bonds or even corporate shares in the most recent crisis, to make sure that the system survives. But this has, of course, massive distributional effect, just the rescue action as such, when you give the support to some, but not to the rest. So in a market-based credit system, this is the same slide I showed you earlier. What the central bank is basically doing is trying to address this problematic cycle where we have fixed interest that can no longer be served because you might have too high default rates by the debtors. And so when everybody else is now scrambling to see whether they have the cash flow they need to meet their own creditors, this can bring the entire system down if also the perception changes. And we all know we cannot enforce all the contracts. So that's where central banks basically go in and they offer liquidity in this cycle. What they do not do, or do much later, typically, I'll come back to the COVID crisis in a second, is to think about what's happening on the debtor front. And for the system to survive, the continuing performance of as many debtors as possible is critical, because otherwise the state has to intervene even more to protect the others. But each individual debtor is not deemed to be systemically important for the system as such. And that basically means that we enforce. We enforce on the periphery of the system, but we relax the full force of the law at the core, at the apex of the system. And that basically reinforces the hierarchy and leads to even greater concentration. It is basically only, when we reach a point where we have either social crisis or political crisis when this stops. And there are lots of examples in history when we've seen that you have sometimes in colonial India, it has been reported that the eviction of peasants led to mutinies and so forth. We see this less today, but I think we have to brace ourselves in the next month. Once this credit cycle, the debt cycle plays itself out, what happens with evictions, what happens with households and small firms that cannot pay their business. So let me just turn to COVID briefly, and just to, again, also think about the amounts of dollars that have been made available to different constituencies. So this is basically just tracking the COVID response. More money has been made available than has been actually spent. This is just for the United States. It would be interesting to just trace that more systematically for different countries around the world. What you can see here is that, of course, the Federal Reserve has the greatest ability to spend, and these are authorized amounts. On top of that, the Federal Reserve can also issue additional liquidity at its own behest. It basically has no limit. It doesn't have a binding budget constraint in that sense, because the US controls the dollar and they can issue as many dollars as they need to rescue the system to fulfill their mandate of price stability. They also have a mandate for unemployment, but that is usually subdued or subordinated to the idea of making sure there is price stability. We have legislative action, and what is interesting to note, I think, is that not all the money that had been appropriated has actually been spent, and that has different reasons. Here's a little bit of a sense where the money went or where it should have gone. One thing that has become apparent is that small and medium-sized enterprises, for example, have not received all the money that they could have potentially received. And this is, again, related to the structure of the system, because many of these, the mechanism for small and medium-sized enterprises to access the dollars is to get loans from banks, because the Fed lends to banks and then the banks lend to small and medium-sized enterprise. I'm just going to open this all up so I can walk you through this. So what we see in a time of crisis like COVID, and this is for the US, it's also true for Europe. I'm sure it's also true to some extent in Brazil and other countries that control their own currencies, where you can have immediate liquidity provisioning by central banks. They go in and are the first firefighters to make sure that the asset holders and intermediaries survive the onslaught of a crisis. In the US, the Fed also has played a substantial role in facilitating liquidity for states and municipalities. That was new. That hasn't been done before, and it might suggest that the Fed will play a more active role here in the future. But this was basically an emergency response. The CARES Act was critically important, and other countries have made similar interventions, but note that many of these interventions were temporary and didn't address the underlying structural issues, which is indebtedness. So I can have a temporary income support for household, I can have a temporary eviction moratorium, I can have lending programs to firms, but of course loans have to be paid back again, right? Maybe on slightly different terms than what you can get in the market, but you're basically levering up. And at some point, all the amounts of money that you haven't paid as the crisis went on are accumulated and very often compounded with interest, and then you have to pay them back. It's also important to note that many of the tax breaks that had been budgeted for were conditioned on protecting employees, and many of these tax breaks have not been taken up by, especially by small and medium-sized enterprises, but also by others, because the cost of maintaining employees were deemed too high. Now, there are different ways, of course, of intervening. In Europe, very often the government picked up the wages, although recent reports suggest that this is also, sorry about this, recent reports suggest that the stress at the firm level is building there as well. So I think what we're seeing here in times of crisis is there are two things are happening. One is really that the contractual and legal structures that we built in normal times that make certain assumptions about how the future will pan out, but also that built into the structures, the expectation of the side that has the stronger bargaining power and has a stronger control over the law means that we create really rigid binding commitments at the lower end in a hierarchical system. And that if at all, when we get into a crisis, the full force of the law is suspended at the top, not necessarily at the bottom, or only later at the bottom, or only temporarily at the bottom. And by these rescue efforts that basically reinforce the structural differences that we built in law beforehand, we're reinforcing the inequalities that we have in the system. So I might be a little faster than you had anticipated, but maybe this gives us a little bit more time for questions and answers. So let me just come to my concluding comments to reiterate, not all legal rights are equal. And I think we really have to come to terms with the fact that in the private market, we are sort of bargaining over rights to some extent, or we certainly are in a situation where parties know how to create powerful rights and make others commit to these rights. Most of us are rule takers, not rule makers. We click agree when we agree to a contract on the internet, of course, but most contracts in the consumer world have been standardized and you sign them without reading because you can't really change them at all. So, and what is in these contracts is ultimately always matters in times of crisis. It always matters in times of default. And that's when we start thinking about how these rights have been created beforehand. You can basically go back into history and trace the allocation of stronger and weaker rights over centuries in different systems. It certainly is the case that in the UK, until the end of the 19th century, landowners had stronger rights than their creditors. But the same English Parliament that upheld that until the end of the 19th century changed the law in the United States in 1732, 150 years earlier, to make sure that the English creditors in the US could enforce against the landowners. So political economy, power relations matter hugely in how you allocate the rights between creditors and debtors, landowners and creditors. And we've seen certainly over the course of the 20th and 21st century, a massive increase of the rights of creditors and a huge dependency of debtors on receiving debt for reasons that have to do with wage levels, etc., but also the legal relationship they have with their creditors, as I explained. The propensity to survive a crisis is strongly correlated, therefore, with the strength of legal rights that one holds vis-a-vis others, and whether or not one is a beneficiary of the relaxation of binding legal commitments. So there's an irony here, right? Is that very often those who impose highly binding commitments on the rest of us are also the ones who are most likely to be the beneficiaries of the relaxation or suspension of the full force of the law in times of crisis. And this is how the system gets reinforced and inequalities even increase. The governmental interventions or the crisis remedies may mitigate, in theory they could mitigate some of the structural effects if they're designed well. That means if we also try to rescue folks on the periphery, even though they might not be systemically important for the system, but it's a moral claim to make sure that we distribute our resources well for those who are actually most in need of them. But very often, as I suggest, the disparities are being deepened rather than mitigated and by protecting the core, but not the periphery. The most powerful equalizer, unfortunately, might very likely be to allow the system to destroy itself. We've seen this in the 1930s. If the system self-destroys, then the level of the inequality in society declines rapidly. Now it can, of course, increase again afterwards. But of course, the political and social costs of such a self-destruction of the system, which is inevitable given how the system has been coded beforehand, are such that nobody really wants to incur them. And I don't want to advocate for that, but I just want to show the irony of basically supporting a system and backing a system through the coercive powers of the state effectively that has these features, that builds a system that has a high propensity to self-destroy. And the only way we can rescue it from the self-destruction is to suspend the full force of the law. And if we do this in this highly unequal fashion, in which we have been doing that, we are reinforcing the very structures that should be changed. So let me leave it here and take some questions perhaps, and I will stop sharing so we can see each other. Let me see how I can do this.
Thank you very much, Professor Pistor. This was enlightening, instructive, and well, I learned a good deal from it. I am not familiar with legal studies and law. And I already see a question there. I had something in mind. I was wondering, if I may, before conveying the question, I was wondering how the notion of corporate personhood in the United States play into this dialectic. As you mentioned at the beginning of the lecture, what we teach, or what you teach usually at the students, is that the private law it originates and works within the framework of our state-made architecture. And this is something that you are questioning, and you are talking more about an horizontal kind of a dialectic there, in which private law has an impact on the architecture itself. And so I was wondering if, considering corporate personhood, we can even talk about a vertical dialectic in which there is actually private law that is shaping and dictating the terms of and it is probably linked to the question of Sergio Chaparro.
Shall I answer first yours?
Yes.
Yes, I mean, as I said, private legal institutions are meant to rank rights among private parties, and private parties avail themselves of state power to do exactly that. They do this with property rights. They do this also by choosing different organizational forms for their business. And of course, a legal person can be created only under the rules of the law, because it's a fiction. It doesn't exist in nature. Such as intellectual property rights don't exist in nature. Financial assets don't exist in nature. We create them in law, and how we create them is critical. Now, the states have allowed private parties to simply register a legal person with minimal requirements. So in the state in Delaware, where most companies are registered these days, it takes a few hours if you pay the right fee to an agent to incorporate an entity. You just need an address, you need a certificate of incorporation, 1 page, and you pay the registration fee basically, and name, an address, name, that's it. And then you have a legal person, and that allows you, this goes back to what I said earlier, now you can transfer some of your assets to the legal person, and now the legal person owns them, so that your own creditors cannot access these assets. So I can use this legal person. Now it becomes more sophisticated. You can design your relationships with employees, with directors, with other constituencies. So this is one of these institutions that has become highly malleable in the hands of private parties. That started in the 19th century. In the 19th century, still you had to get either an act passed by a state legislature, or you had to get government approval to set up a corporation. Today, you can do this very easily. And on top of that, this is really important, you can choose in which jurisdiction you want to incorporate your entity. And that very entity, even though it's a creature of that jurisdiction, will be recognized as a legal entity almost anywhere else in the world. Which is why you can be in Delaware and never do business in Delaware, operate only in California or in Israel or somewhere else in the world or in Italy, and benefit from the rather pro-managerial and shareholder-friendly law of Delaware while you do business elsewhere.
Thank you. Well, I only see, I am not aware if I am looking at the right place, but I think I am. And in the Q&A box here, I have one question. Yes, I see questions coming in. So let me convey the first one. I think I should read it for the audience. Sergio Chaparro asks, is it possible to invert the hierarchy of finance using law under a capitalist economy? In other words, is it the constitutive role of law autonomous enough from material constraints to think law can prioritize the interests of actors at the bottom of the pyramid?
So I think law can do this. The big question is, can law do this in the capitalist system? And this is, a little bit tautology in my world, because I've argued in my book, The Code of Capital, that capital is coded in law, right? That a particular way in which we have used these institutions, property rights and our debt contracts, the trust, the corporate entity, the bankruptcy, has always sort of created hierarchies and created new types of power relations. Could law be used in different fashion? Yes. Would this still be a capitalist system? Probably not, because in my world, capital is the essence of capitalism is really to be able to harness the powers of the state in the form of law to create more powerful rights for some, which they can exercise over others. So. But you can mitigate it. I mean, we've seen more moderate forms of capitalism, at least in the past. If you think about the big debates we had in the 60s and 70s about the Rhine model or the varieties of capitalism, so you can mitigate the beast by making it less easy for private parties to avail themselves of the law in this fashion. But I think in a latent fashion, this hierarchy, these some having better rights and being able to use the law to create them even more, and in a highly competitive way in which the law itself becomes the stuff that we are competing about, that is, I think, built into the capitalist system as we know it.
Thank you. I do have a question which appears unclear to me, perhaps due to a typo in the question. Nayana Shirado is asking, what I suppose the question is, what is the best social program, or if the best social program is that of creating jobs? I don't understand really well this question, but
I don't quite follow this either, but maybe she can retype. Just yes. Let me just say that we could, of course, and lots of people are arguing this, that in the COVID context, the government should play a much more forceful role in creating job, and maybe in general there should be a governmental job guarantee. That would help, because you would basically guarantee households and future income flow, even in times of crisis. And that would allow them then to pay their bills, pay their debt, and do everything else. It doesn't really mitigate the structural features of the system entirely, but it would certainly be of help, let's put it this way.
Right.
Could I ask a question?
Yes, you can, Thomas.
Okay, I cannot type it into the Q&A because I'm one of the speakers, so I'm sorry for that. What interests me, you spoke very elaborately about the system and how the system works, and I would like to learn a little bit more about how the system evolves, how the system changes over time, what shapes the system. So at one extreme, you might imagine that it is very explicitly shaped by politicians, legislators, and so on. They create a certain legal framework. And I'm sure there's something to that. And of course, these legislators don't operate in a vacuum. They get influenced and lobbied and so on and so forth. But then from what you said, there's also a good bit of just practice that shapes the system. Of course, legal practice, and also the individual players who make certain contracts with each other. anyway, if you could speak
Yes.
to that problem a little bit more, that would be very interesting, I think.
Yeah, no, I think that's a really important point in my view, is that I think sometimes we think too much of the state basically framing the system, and then everybody plays within that system. And if we change from the state legislature or even the regulatory side, something that the system will change. When you look at the private law side and how people transact, private lawyers will tell you that they basically look at the legislature or the regulation as the scaffolding. And in order to help their clients get a competitive advantage over anybody else, you have to build a new type of transaction or financial intermediary that fits within the gaps of that scaffolding. So it has to be legal, can't be illegal because then it fails, but it has to be legal but not incur the legal costs that come with the legislation or the regulation. How does the system evolve? In my book, I talk about the masters of the code. And I'm basically saying that the private attorneys are the masters of the code. And you can, so we can trace this, especially in the common laws. I think the common law has a comparative advantage in that sense that it has empowered private attorneys to engage in these transactional law, and the judges who might oversee the transactions that have been created are recruited from the bar. They're coming from private legal practice. They first practice a couple of decades, then they become judges. So the likelihood that they will recognize and enforce the latest legal innovation of their former peers is much greater than in a civilian system where you have bureaucrats sitting as judges. So I think there's a very strong common law legacy here, history of an independent legal profession that has helped individual clients to build their wealth through using these legal devices, and they have been highly competitive. If you look at the world today, we all know that the biggest financial intermediaries are sitting in London and New York, and there's some competitors coming up, but they're still sitting there largely. But in London and New York, you also have the biggest top 100 global law firms that have offices in more than one jurisdiction. So this goes hand in hand, and they're basically coding the interests of their client, and they're choosing the jurisdictions that give them the greatest flexibility to do that. And these are typically the laws of England or the laws of the United States. They're very often used also in global context. So I'm basically arguing that most globally traded assets are actually coded in these jurisdictions. And this is possible because most other countries do recognize and enforce the laws of England or the United States or of Delaware or of New York. And so you can pick and choose. You can pick and choose the laws by which you want to be governed, and that undermines this whole notion that we as democracies adopt legislation by which we're governed, because if you know how to opt out of that, then you can free yourself from that state. You're still dependent on a state to code your legal assets, but it doesn't have to be that one state, and then you can shift around. We know this from tax evasion, but we know this from regulatory arbitrage. That's how we do this, right? And the more we rely, and the more of our wealth is created through legal issues, legal things such as patents or corporations or financial assets, the more we can actually use the law itself to recreate the system. And I think that's where we are.
Thank you. I have two questions. I will read the second one first because it's probably a little bit more related to what we are discussing at this point. Reda Mokhtar El-Ftou, sorry for the pronunciation, is saying, thank you very much for this incredible presentation. And the question is, could job income guarantee and monetary financing help escape the structural aspects of the system that produce inequality, or could they contribute to reinforcing them even more?
Well, it depends. I take this a little bit to be a question about sort of the modern monetary theory. So we're basically using the power to issue money to ensure that we can harness the full productive capacity of the economy, including employees in particular. So the binding constraint then, as folks like Stephanie Kelton and others argue, is then inflation rather than something like a deficit myth. And I think one important issue here is that we would at least get out of this spiral of thinking and acting in terms of debt dependencies, right? This is one of the big political debates, especially in this country, but has been in Germany. It seems to be shifting in Germany as well with the black zero. I think we're beyond that now, that the state itself is perceived or portrayed as an ordinary debtor that has to balance its balance sheet. If we get over that, then the state has more flexibility to use its resource. And one of the most powerful resources is to have your own currency that you can issue, and you can force others to use it because you tax them. So they need to have that currency to pay back the obligations they owe to you, and that's how you make sure that people actually use your currency, at least those over which you have control. Can you completely revamp the system? I think we should not be too sanguine about that. We have to realize that the monetary system that we have today is a hybrid system in which banks issue their own money as well. That's private money, and that interfaces with public money. And the effect that different channels, or how you use private money and how you make it convertible or not, or you actually use dollar denominated asset rather than another denomination, will have an impact also on the sovereign currency. So I think it could make a huge difference in terms of thinking what the state can do, but we're doing this in the context of a system where private money, credit money, is the dominant form of money, which is backed by state money. And if the backing structure changes, the private structure will have to change too, but we probably cannot entirely predict exactly in what sense it will change immediately and how we can rechannel it in the longer term.
Thank you very much. I want to read this question now. It's Gabriel Amitzis. What do you think about the conflict between economic rights of private legal persons and social rights of persons at risk? The request is for a comment about the protection of first residents of over-indebted families to private banks.
Yeah. So I think, the system that has evolved over a longer period of time has given private parties the power and the possibility to forge their rights in property rights and other things. We have relied for our social rights mostly on the state. And as others have said before, Reich has talked about the new property rights in the 1960s, so these rights that are granted by the states are typically weaker because they're always contingent on being withdrawn again. The state gives you some social rights for some time and then doesn't have the spending power, we're coming back to that issue, and then takes it back again. Whereas the property rights that we create are protected, not only property in private law, they're also protected in constitutional law, and so they get reinforced. So the big question is basically, could we also, and what we want to do this, leave it to private parties or encourage coders of the law in the more private transactional fashion to protect individuals with the law? Or could the state do it in such a way that it actually makes binding commitment, lasting commitments to help vulnerable people? It's probably the easier strategy to think about, but that would have to be done, because I think reliance is the only constraint right now on states taking back the generosity, and it's always like it's a generosity, it's not a right. The beauty of the private coding of these wealth creating assets is it's perceived to be a right. It's enforceable when I want to enforce it. I might not always succeed, but that's what I can do. Whereas the social rights become dependence on the generosity of a state at a particular moment in time.
Thank you. Now, I guess we have another 5 or 7 minutes. We can gather a few more questions, if this is possible. I would like to have well, one question is a very short one, and is about this high irony of self-destruction as equalizer that you were talking about. What Juliana Gak is asking, what does the self-destruction of the system mean?
Yeah, so if we all enter into contract with one another that are binding and will be rigorously enforced, that was saying, you pay me $50 and 10 days plus interest. And then you also make similar commitment. Everybody makes kind of commitment. We all assume that the world in 10 days, or let's say a year, looks like the world looked today. So it's not such an unreasonable assumption unless you get something like COVID or you get a financial crisis, right? So we make these commitments, we incur these obligations. If you enforce all of these obligations when the circumstances have changed without adapting that, you will bring the system to its knees because nobody will be able to pay. And those who can't get the money from their own debtor, they have promised to pay back their own creditors. And so the system basically collapses into itself. So our credit-based financial system, which was what it is basically vulnerable to these shocks. We knew this from banks. This is why we regulate banks. We have recreated the system as a market-based shadow banking system, we call it, but it's really market-based credit system, which has exactly the same kind of features. If you have all these fixed incomes claims against others, you will also use your right in times of crisis to enforce them, because as a private entity, if you can't get the money back from the others but have to pay your creditors, you go bankrupt. Right? We have a pretty brutal system. If you can't manage your assets and liabilities, you go bankrupt. So you will enforce. If everybody enforces at the same time, no doubt the system will self-destroy. And from that, you can come back only by saying, actually, let's stop this. You can't enforce. We do this on an individual basis in bankruptcy. That's basically what a bankruptcy procedure does. The individual creditors cannot enforce against the debtor. Time out at least. Now we sort of collect all the claims, and then you get a pro rata from whatever assets are left, right, on an individual basis. If you have a system-wide effect, using bankruptcy is not a very powerful thing because it takes too long, right? And so what the governments then do is they intervene through debt moratoria, sometimes temporarily, or they bail out banks because they're afraid that the entire banking system might fail, etc. So we get interventions to prevent. And I'm basically abstracting from exactly what they're doing and saying essentially what they're doing is that they are suspending or relaxing the contractual commitments that folks have made to one another by giving somebody the money that you don't owe to them, right? So you give the money liquidity support. If you give a bank liquidity support, it's basically because you don't want it to fail, but you don't really have a legal obligation to do so. It's a discretionary act of power.
Thank you. Rodrigo Salgado is asking, well, the beginning of the question is stating, in the beginning of the year, Professor Pistor pointed that necessity of a free money, quote unquote, embodied with a demurrage feature to avoid both inflation and the lack of circulation. Could you comment about these and say if it still is a good idea almost a year after your proposal?
Yeah, I think I wrote a little blog in March actually, and trying to revive ideas of other writers that had come earlier, who basically said, you know, the nature of the money is ultimately critical for the distribution of wealth. Communities need a means of exchange, and you can create a means of exchange. And one of the ways in which we have turned a means of exchange in a wealth creating vehicle is of course by charging interest. But if you do the opposite, if you hold on to that money rather than recirculate it, the money loses value. There is some, not much, but there's some historical evidence that communities that have done that have actually seen greater levels of equality, because this power to use money itself as a source of extraction basically is taken away by forcing you to recycle the money. And if folks have something to, you know, exchange their goods, services, whatever they can do within a community, then they might actually survive also in times of economic crisis. So there are examples from Germany in the 1930s where cities issued these kind of currencies and did really well. What typically happens is that the central state comes back and say, you can't do this because we are the money issuer, you're not the money issuer, right? They tolerate private money issuers, private banks who issue credit money, but they don't tolerate other public entities to do so. And there are more sophisticated schemes out there. Robert Hockett at Cornell has developed that, and there are even legislative proposals that have been introduced to the parliaments in New York and other states and other communities in Switzerland and elsewhere are using it. So it's not completely new. I think it's still a viable thing to consider if we want to revitalize communities and their economic activities. And with the digital capacity that we have today, we could actually scale it much beyond just small communities where people know each other. And that's part of the proposals that are currently being developed, I think.
Thank you. I would kindly ask, I suppose it's Raquel Ilha to mute the microphone. We have a background noise here, and I see the only one in my screen unmuted is.
It might also have been on my side because my husband was walking down the staircase. So.
Excellent. We have another couple of questions. I think we can see what we can do with these questions. I think one is related to the discussion about the hierarchy of rights in general. So Jomo is asking, in the context of the rule of law today, can one realistically expect human rights to overcome property or contractual rights or trump them?
The way we have configured the system, almost no, right? In most constitutional system, property rights is also considered to be kind of a human right, and you can make good arguments for that as well. So that's sort of one of the internal contradictions. Don't we all have to have some assets with which we can exercise our self-authorship, as Hanoch Dagan or others might put it. So there's there's within the world of human rights, there's already a tension. But more importantly, in most legal systems, the idea is that your human rights or civil political rights are rights against the state, not necessarily against other private parties. So we have this tension built into our legal systems, also in democratic constitutional systems, that private parties can configure their own rights. They're not subject to the same constraints that the state would be under. Doesn't mean that private parties can engage in human right abuse, and we can adopt legislation that constrains them to some extent. But in principle, the way these rights have been configured is that private parties have much greater leeway in using, again, they're also using the power of the state. I think that's really important to realize. This is not a market outside a state system. It is harnessing the coercive powers of the state for your own private transactions, and doing it in a way that is allowed to maximize your profit and economic interest, even at the expense of others, right? So one would have to think deeper about how to reconfigure that system and give private parties more rights to use human rights arguments, perhaps against other private parties. But that would be a big step, especially in the United States, but even in other countries as well.
Thank you. I'm aware of time. I think we can gather one more question. I am also aware of the fact that Dr. Heijun Chang has limited time for us. So the last question I would like to gather is, well, now we have a new one, and I'm going to read this. Well, one question is about authoritarianism. Can we speak of an authoritarian scenario in this respect? And the other one is more technical, and it's, do you think interest rate capping is a way of inverting the pyramid?
I think right now we're in such a low interest rate environment, and we see a very steep pyramid, that this is not the only issue, right? So so I think it could flatten it out. And I said this in the terms of, when we talk about demurrage functions or aspects of currencies, that interest is of course one way in which you can make money, but you can also do it by, trading your assets in a capital market and trying to make a cut on the difference. So it probably wouldn't be the only thing. In terms of suspending the law, then typically, and I'm saying this is what we observe. It's not something, of course, that I normatively would support or that I think is necessarily so, but we very often observe that actors such as central banks in particular, when they intervene in financial markets, they do this to protect the system, right? And they protect it so that they don't have to protect the entire system, but they protect the core of it. Is this authoritarian in the sense is that the system is hierarchical and they're basically intervening at the very top. They also very often intervene far too late because they allow the stress to be built on the periphery, to build up at the core, so that they have no choice in the end, or they at least believe to have no choice, but to rescue the system at its very core. And there is something, that's certainly hierarchical to it. The question is whether you could compel central banks and others to do otherwise, right? And whether we could create mechanisms, something I've been thinking about that, those on the periphery, households, others, might be able to raise a white flag and try to trigger some remedies earlier on so the stress doesn't begin to build, so we can flatten out the crisis much earlier. But this would be, you would have to think this through and think how this fits into what we have to do to change the system to make this more feasible.
Thank you very much, Professor Pistor. It was a pleasure and an honor to learn from your lecture and from the Q&A.